So I think we always seem to a little bit forget to introduce the chairs, actually. So I thought I'd quickly do this. So this session will be chaired by Jansen Calamita, who is a senior research fellow and director of the Investment Treaty Forum at the British Institute of International and Comparative Law. And well, I actually hand it over to you because I think we really would like a lot of discussion time rather than me talking.
Oh, is that it? Are we on? Okay. Oh, I hadn't realized we'd started. Good morning, everyone. Yes, my name is Jan Calamita. I am the director of the Investment Treaty Forum at the British Institute. It's a pleasure to be here, and thank you all for turning out bright and early this morning. This is an amazing view. I've never been in this room before. It's lovely. Today's focus is on dispute resolution and small states. And we begin with a panel on dispute resolution involving states, both states as claimants and states as respondents. States involved in disputes with other states and states involved with disputes with non-state actors and in particular investors. We have four terrific speakers to guide us through some of the issues raised in this area. To my right is Stephen Fietta, who is partner and founder of Fietta, London. To my way down left is Brian McGarry, who's director at the Center of Diplomacy and International Security here at the Center of International Law and Practice in London. To his right, Dominic Roughton, partner at Herbert Smith Freehills, and Lauge Poulsen to my left, lecturer at University College London. So without more, and without wanting to take more time away from discussion, let me turn things over to Stephen to begin. I think it's just on, actually, because it's red.
Thank you, Jansen, and thank you for our hosts at BIICL for organising this event and for inviting me along. I'm going to give an introduction, I think, to this morning's topic relating to small states and international dispute resolution, whatever form that may take, whether it be litigation in the International Court of Justice, arbitration, ad hoc or institutional, conciliation or otherwise. And I think I'd start with the observation that unquestionably small states have been active and comparatively frequent users of international dispute resolution. And I don't think this is a recent trend. It certainly is the case over the recent decade or so that small states have been very active, but I think it is a perennial feature of international dispute resolution. And many of the seminal cases in the annals of the International Court of Justice involve at least one small state. So this is very relevant to small states. And that's because small states often find themselves needing to resort to international dispute resolution, international courts or tribunals in order to secure satisfactory outcomes or outcomes at all to their disputes, particularly with larger neighbours. Without the military, economic or political clout of their neighbours, international dispute resolution can be by far the most effective way forward and most attractive way forward for states in settling their disputes. But more importantly, the peaceful settlement of disputes is of course a requirement, a fundamental requirement of public international law, both customary and under the United Nations Charter. And what is more, international dispute resolution mechanisms promise a level playing field between all states. No matter the size of the state or the economic power of the state, it is treated as an equal vis-à-vis the very largest and most powerful states when it comes to international law and international dispute resolution. And that, of course, is thanks to another fundamental principle of public international law, that of sovereign equality between all states also reflected under Article 2 of the UN Charter. International dispute resolution can be particularly important in situations of substantial sensitivity, such as disputes over nuclear proliferation, environmental protection, territorial sovereignty, or maritime delimitation. These are very, very sensitive and difficult issues, and they have been at the centre of a number of recent disputes involving small states that have found themselves to binding dispute resolution. So, where a jurisdictional basis can be established, international dispute resolution has been a popular choice for small states and has led to some notably positive and happy outcomes for a number of those states, often against very substantial, large and powerful adversaries. So in my presentation this morning, I'm going to address just three features, but I think they're all important features of cases of international binding dispute resolution between states involving small states in particular. The first feature I will look at is the trend, as I mentioned, among small states to resort to international dispute resolution as a means to resolve disputes that have become bogged down in negotiations with neighbours or with very large states, or perhaps have not even been the subject of serious negotiation at all, because some small states simply cannot get a serious audience with a large state in relation to some issues. I'll look at some examples of where that has happened. The second topic I'll look at is the topic of jurisdiction. It's a fundamental question to this topic. All states looking to commence dispute resolution procedures against other states will be faced with questions of jurisdiction and the challenge of finding a basis for jurisdiction, which can, as we'll see, be quite difficult and complex. And third, I'm going to look at choice of forum. If there is jurisdiction, which fora are available, and if there is a choice, if the states concerned or the state concerned is lucky enough to find itself with a choice of forum, what particular factors might impact that choice for small states. In addressing these three topics, I'm going to touch periodically on five recent and in some cases ongoing cases involving what I would call small states. The last one doesn't strictly fall within the definition of today's session. The five cases are Mauritius against the UK, which was a recent arbitration under UNCLOS, relating to the declaration by the United Kingdom of a marine protected area around the Chagos Islands. The second case I'll touch on is Marshall Islands against the UK and others. Marshall Islands has brought cases against a number of states, nuclear weapon states, relating to the Non-Proliferation Treaty and related obligations. Third case I will touch on from time to time is Barbados-Trinidad, which was the first Law of the Sea arbitration under the Convention on the Law of the Sea, related to delimitation of a maritime boundary between those two states. The fourth is the Timor-Leste Australia dispute, which has given rise to a number of litigations, settled and ongoing. And the final case I will touch on from time to time is the Philippines-China case. Now, obviously, neither of those states is a small state. Even Philippines itself has a population in excess of 100 million, so it does not meet the definition of a small state for today's purpose strictly. But the dynamic, I would say, of that dispute is quite typical of a dispute between a comparatively small and economically powerless state against a large behemoth of a state and moreover a permanent 5 Security Council member. And so I do think it's worth touching on that dispute in the context of this topic as well. So the first topic really concerning situations where states have referred to international dispute resolution, and done so in many cases successfully in order to break a cycle of entrenchment or frustrated negotiation or non-negotiation. In these situations, typically the dynamic is a small state facing a dispute with a comparatively much larger state. It may be a distant larger state, and it may be a P5 member of the Security Council. A classic recent example of that dynamic was the Mauritius UK Dispute, which, as I mentioned, related to the UK's declaration of a marine protected area around the Chagos Islands. And this marine protected area was very large, and it would have had a number of, Mauritius said, prejudicial impacts on both its core state interests and the interests of its nationals, not least because the Chagos Islands are a part of the world over which Mauritius claims sovereignty, and the fishing constraints would have affected its own nationals. And in fact, it was accepted in the context of that dispute that in the past the UK, in the context of the independence of Mauritius, had undertaken to return or pass sovereignty over the islands to Mauritius at some point in the future. So Mauritius clearly had a very, very core interest in this marine protection area and the declaration of it. But Mauritius complained that the UK had not really consulted with it at all in connection with the declaration of this large marine protection area. It came up with the idea in 2009, reportedly, and the UK declared the area just over a year later in 2010, having not consulted very much, Mauritius said, at all with Mauritius, having consulted much more, it said, with its good friend and ally, the United States, which of course has a military base on Diego Garcia in the Chagos Islands, and having consulted with the UK population by way of a public consultation as well. But Mauritius felt left out, and it certainly felt that given that these islands were likely to revert to it in the future, that this declaration of a marine protection area prejudiced its interests. Frustrated by events, it resorted to binding dispute resolution under the law of the Sea Convention. By virtue of the United Kingdom and Mauritius being parties to that convention, they have agreed to refer disputes under it to arbitration or other dispute mechanisms, and I'll come to that in a little more detail shortly. And in short, the Mauritius case, although both sides have claimed victory, because certainly the UK won on some issues, on jurisdiction in particular, the case was successful for the small state in a number of important respects, not least the Mauritians secured confirmation in the award that undertakings to the effect that the Chagos Islands would be returned to Mauritius in the future were binding on the United Kingdom, and that the marine protection area, or in declaring it, the United Kingdom had violated its obligations under the law of the Sea Convention, not least to consult with Mauritius and inform it clearly as to its intentions. No doubt, I think that may be have been a catalyst for the Marshall Islands to bring their own case against the UK and others. Very different context. That one's ongoing, and I won't say too much about it, but it relates to another very sensitive issue of nuclear proliferation and disarmament. That case is in the International Court of Justice, because, as I mentioned on my second topic, that was the body which will have jurisdiction over that particular dispute. A third example, my third example was the Barbados-Trinidad case, a case close to my heart, as I was counsel for Barbados in that case. It was the first delimitation dispute, maritime boundary delimitation dispute, which found its way to arbitration under the law of the Sea Convention. the dynamic there was a comparatively small state against a comparatively larger and more powerful state. Trinidad has a GDP of approximately 10 times that of Barbados. And the Barbadians decided to refer the case to binding dispute resolution following about 30 years of frustrated negotiation, fishing arrests, and discussions which the Barbados Prime Minister described as having become intractable by the end, by 2002, 2003. As a result, Barbados decided to exercise its right under the law of the Sea Convention to bring a case against Trinidad in order to resolve the maritime boundary. It did so successfully. It didn't win on all points, but it secured a boundary that was fixed in law and which allowed it to move on by launching a significant offshore hydrocarbon concession round, which otherwise it would not have been able to do because concessionaires would have seen the area as a disputed area. And also it gave its fishermen, fisher folk, the right to continue fishing in areas that they had traditionally fished. So these are just examples, and there are others, and we may be faced with another soon with the imminent award of the Philippines-China Tribunal of successful outcomes for comparatively small states in bringing dispute resolution, binding dispute resolution proceedings against larger states. My second topic is jurisdiction. Now, the question of jurisdiction is fundamental, and I thought it was important to address it at the outset of this session. It's fundamental in international law generally, but it's particularly fundamental in the context of state-state disputes. Without consent of both parties to find themselves before a court or tribunal, that court or tribunal will not accept jurisdiction. And it is very, very pertinent to this topic because, as the record shows in cases involving small states, particularly cases brought by small states, there is almost invariably a series of jurisdictional objections made by the respondent. They don't want to find themselves in a court or tribunal, more often than not, and perhaps they don't want to find themselves on a level playing field. So disputes or objections to jurisdiction are common, and in the cases we're looking at that I cited as examples, they were present. The UK has objected to jurisdiction in each of the cases that I mentioned. Trinidad objected to jurisdiction in the Barbados case. China fundamentally objects to the jurisdiction of the UNCLOS Tribunal to the extent that it has not even turned up or engaged in the process at all. But the process continues. And in each of these cases, at least the ones that have been decided, the jurisdictional objections have been overcome. Now, the most straightforward way to establish jurisdiction, of course, in any state-to-state dispute is by way of mutual consent expressed in an agreement related to that specific situation. So an agreement between the two states that they have differences that they've been unable to resolve and that they wish to refer to an international court or tribunal. There's numerous examples of that over the years. None of my recent examples, falls into this category. But an early and seminal delimitation case, maritime delimitation case, was the Libya-Malta case. Malta, of course, is a small state. That was referred by agreement to the International Court of Justice successfully in the 1980s. But even when a small state thinks it has an agreement to refer to dispute resolution, that may not be a bar to a jurisdictional objection. We saw that, for example, in the Bahrain-Qatar case. Bahrain comparatively is a small state as against Qatar. Again, its GDP is under 10% of that of its neighbour. Bahrain thought it had an agreement to refer its dispute with Qatar to the International Court of Justice, only to find that when referring the dispute to the court, Qatar immediately resisted jurisdiction, with the result that the state had to go through proceedings on jurisdiction and win them before the court could proceed to the merits. A second potential basis of jurisdiction, very relevant to our topic, is cases of standing consent of the states concerned under normally a multilateral treaty. The most obvious and commonly used example is the International Court of Justice's own statute, to which all UN members can make optional declarations accepting the compulsory jurisdiction of the International Court of Justice. Other treaties contain standing consent for specific types of dispute. The best example is the Law of the Sea Convention in relation to law of the sea disputes, and there are a multitude of other more specific treaties such as the Narcotics Convention that include International Court of Jurisdiction consent. The problem with this, though, quite often is, well, first of all, in connection with the optional clause declarations before the International Court, comparatively few UN members have actually accepted the standing jurisdiction of the International Court of Justice. This is a perennial problem and challenge, actually, for the court. We checked, and at the moment, 72 states out of 193 UN members have accepted the jurisdiction of the International Court of Justice. And of the permanent 5 Security Council members, only one, the United Kingdom, has done that. So the International Court of Justice is not an easy place, most often, for a small state to take a large state to binding dispute resolution. Moreover, where states have accepted the jurisdiction of the International Court, they have often done so subject to limitations, and hence the United Kingdom is objecting to jurisdiction in the Marshall Islands case. Another important constraint often on jurisdiction is the ability of states to pull the plug under a treaty on a jurisdiction that would otherwise be there. A classic example is the Law of the Sea Convention. A state, by signing the Law of the Sea Convention, accepts to refer disputes relating to it to international binding dispute resolution. However, under Article 298 of that convention, any state party can enter a declaration withdrawing its consent to binding dispute resolution over certain categories of dispute, including, importantly, disputes over maritime boundaries. And the exercise of that declaration right has posed and continues to pose very significant problems for small states in a number of dispute resolution, maritime boundary dispute resolution settings. There are 2 good examples of this. The first one is in the Caribbean, where, as I mentioned, Barbados successfully invoked the Law of the Sea Convention in its dispute with Trinidad. Trinidad was a party to the convention, remains so to this day, and had at that time accepted, as a result, the jurisdiction of the Annex 7 Arbitral Tribunal, in effect, under that treaty. Barbados, as I mentioned, successfully navigated that case and secured an outcome with which it was happy. However, almost immediately, Trinidad withdrew its consent to any future boundary delimitation dispute in the Caribbean. It has a number of unresolved boundaries, not least with Grenada. And as a result, that boundary dispute will probably never find its way to a binding dispute resolution process, at least under the Law of the Sea Convention as it currently stands. Other very well-known examples of withdrawal from consent and therefore jurisdiction under the Law of the Sea Convention are Australia's withdrawal just a few months before the independence of East Timor, and China's withdrawal of any consent, which of course is causing challenges for some of its neighbours wishing to resolve disputes in the South China Sea in particular. So all of these and other factors will often lead to jurisdictional objections whenever a small state takes another small state, or particularly a large state, to a binding dispute resolution process. So small states need to be ready for that, plan carefully, and choose their forum very carefully, which will be my last topic in a moment. But before I move on from jurisdiction, all is not lost in a situation where it looks like no court or tribunal has jurisdiction over a particular problem. There are other options available, or that might be available. Some situations this will be more straightforward than others. Now, a classic example of a situation where international dispute resolution is very difficult is in international environmental law. Now, I teach a class on that at King's College here in London, and one of the first things I always say in that class is that it is very, very hard to take a dispute relating to the environment to an international court. Why is that? Because there is no standing international court related to the environment. There is no multilateral treaty related to the environment that contains hard provisions binding the states, including to binding dispute resolution in the event of disputes. That has left states facing problems as a result of climate change with significantly less options, because there's no court or tribunal that clearly has jurisdiction over that type of dispute. However, Palau, which we all know is a small state in the Pacific, in an attempt to get around that problem, is reported to be looking at trying to pass a resolution in the UN General Assembly in order to refer a question to the International Court of Justice for an advisory opinion. The International Court of Justice has jurisdiction and must, in fact, respond to advisory opinion requests from the UN General Assembly, and they can be passed on majority vote. Through that means, Palau is at least considering securing an opinion from the International Court of Justice related to the obligations of states, including the largest industrial states, to mitigate climate change. Other examples of situations where advisory opinions have been sought related to issues that are central to small state interests. Two very, very well-known recent examples are the Kosovo opinion on the legality of the Declaration of Independence of Kosovo and the opinion on the Palestinian wall. And finally, a quick word on conciliation. Conciliation is another option for states where, under the law of the Sea Convention, for example, the respondent state has withdrawn its consent to a binding process. Conciliation is non-binding, but East Timor has recently commenced a conciliation against Australia with a view to trying to make progress on its boundary dispute in the Timor Sea. My final topic, and I'll spend only a minute on it, is a choice of forum. If a small state has the luxury of a choice of fora, then that's great, because it means that more than one forum has jurisdiction, most likely, which is quite rare in this situation, but it does happen. And therefore there are situations in which small states will need to consider which forum is likely to work best and most likely to achieve its objectives, whatever they may be, in referring a dispute to binding resolution. Now, I haven't got time to go through the many factors that may inform a call on which forum to go for, and I think Dominic may address this issue in a little more detail later. But just a couple of factors I wanted to mention that may impact a small state's choice in these situations, particularly where the dynamic is a small state against a large state or a P5 state. Now, in that situation, some small states have chosen very deliberately not to go to the International Court of Justice. All of the P5 members, of course, have standing judges on that court, and a number of them are quite closely, have close relationships. And the dynamic, therefore, for a new state or a small state bringing a case against a P5 member may be quite challenging in the International Court of Justice. And I think that was definitely a call taken by Mauritius in its case against the UK, not only because the UK is a P5 member, but also because that case involved very significant interests of the United States. In that situation, it probably made little sense for the Mauritians to bring the case before the ICJ if they had the option of going to arbitration. On the other hand, my final point is that the International Court of Justice may, of course, be a good option in other situations for small states, particularly if there are issues around enforcement, if there are concerns over the enforceability of a decision. The International Court of Justice probably, for lots of reasons, renders the most authoritative and binding awards of all. And if there are concerns, on the other hand, over timing or flexibility of process, arbitration may be a better option for a small state. I'll leave the discussion there, but certainly by way of conclusion, I would say that binding dispute resolution has and continues to be a substantial tool for small states in resolving disputes, particularly and including against larger states. There are many examples, perhaps an increasing number of examples, of small states resorting to courts and tribunals and the level playing field that they provide in order to resolve their international disputes in situations which are otherwise, in the words of the Barbadian Prime Minister, intractable. Thank you.
Thank you very much, Stephen. Thank you, Stephen, for identifying some of the promises and the challenges that small states face with respect to binding dispute resolution in the international legal system, particularly given the consensual nature of disputes and jurisdiction in public international law. One point that you made at the outset was that one of the attractions of dispute resolution mechanisms for smaller states is that it holds out the promise of a level playing field for smaller states. And of course, in order to achieve that level playing field as a practical matter, it requires the hiring of lawyers and the assembly of defense teams or claimant teams.